Hello, everyone. Thank you for joining our webinar presentation. This is Alex Anglum from OGC Solutions, Santomassimo, Davis. We're very happy you're able to join us today for the Directors and Officers presentation. We will take you through a few introductory items first before we get into the meat and potatoes of the presentation. First, as I said, I want to say hello to everyone. Thanks for joining us. And this is our agenda for the day. We'll tell you a little bit about my firm, a little bit about my co-panelist, Brian Liddell, and his firm, Fidance Insurance Brokers. And then we'll talk about the value of D&O for private and nonprofit companies. We'll talk about going to market and applying for coverage, getting the best possible coverage, where we focus on some differences in the various forms, terms, and conditions that are available that you'll want to think about. And finally, we'll conclude by just briefly hitting the topic of developing an insurance program with the help of your professionals. With that, let's tell you a little bit about our firm. Santomassimo Davis focuses on the outside general counsel solution for our clients. We're a boutique, business-oriented law firm, and we provide experienced, business-minded counsel to our clients. And more so than other typical law firms, we strive to be an outsourced legal department. So we duplicate the ability and the breadth of practice of an in-house legal department, as you would find in a very large company, a Fortune 500 type company, but we do it on an outsourced basis so we can bring that structure to mid-market clients, give them full access to our team. And we are able to do that on a fixed fee basis, where our firm will actually take the business risk and undertake the possibility that the hours might exceed the allotment, rather than a retainer, which is just a prepayment for a certain amount of legal services. We like to think that makes us a lot different. We've had many clients be very happy and continue to be very happy with this structure, and we continue to refine it and make it an ever-increasing focus of the way that we practice law and the way that we market to clients. As well, I want to tell you about my co-panelist, Brian Liddell, Managing Director for Fidance Insurance Brokerage. Brian provides independent representation in the insurance marketplace. He has the CPCU designation, and he served as a business developer for the United States, London, and Bermuda insurance markets. Brian also is, as you will hear, an interesting and energetic speaker. He has a law degree, a lot of breadth of experience. It really gives him a unique ability to speak to some of the issues we're going to bring to our audience today. His company, Fidance Insurance Brokerage, is a commercial insurance brokerage and serves as a confidential advisor on the management of risks without partiality to any particular company. They're independent. Or just the kind of professionals that you would want as you sort through the kinds of issues we're going to talk to you today for directors and officers insurance. Before we get into some of the nuts and bolts of this coverage, we want to hit a little bit of material regarding what is the value of this important insurance product for private and nonprofit companies. And as you saw from the promotional material and the agenda today, we are focused on private and nonprofit companies, not on publicly traded companies, which typically have the risk of securities claims against them, and for which D&O insurance is often a focal point of the securities risk. Private companies are a little bit different, but it's no less valuable. The types of claims that can be covered under directors and officers liability policies can be quite large, big ticket, large exposure type of claims that are expensive to defend and resolve, even if there's no wrongdoing. Typically, more sophisticated counsel is needed at higher rates than you might see in, for example, a slip and fall under your general liability policy. If D&O policies are structured properly, they can protect against allegations of intentional wrongdoing, like accounting fraud or self-dealing or other breaches of fiduciary duty, which is an important benefit. These policies can also protect innocent directors and officers against claims that arise from things that other directors and officers might have done intentionally wrong. Again, a very important benefit and a consideration when going into the market to buy these policies. Also, if structured properly, they can protect the personal assets of the directors and officers. And hopefully, this is a focal point when you're buying the policy. And that could be true even if the company, in other words, the insured company, is insolvent. So they could provide more financial protection for individual directors and officers than the company itself could provide, even if it chose to do so. They can also pay the cost of responding to government investigations. And of course, you should always keep in mind that when you're adverse to the government, it is a formidable adversary with virtually unlimited resources. So again, taken all together, these are some very good reasons that have always existed for private and nonprofit companies to have this important coverage. That's only increased in the post-COVID environment. As I'm sure everyone who can hear me now knows, there have been massive new government programs as a result of that were part of the CARES Act and the other COVID-related relief acts. Paycheck protection loans, the related forgiveness of those loans, economic injury disaster loans, shuttered venue operator grants. These are all very, very large government expenditures that have been made to private companies that are based on applications and certifications submitted and that have to be truthful. And if they're not truthful, or if there is a potential untruth in those applications, you could find yourself on the receiving end of a government investigation. We've seen in the news that the early investigations of these programs have focused on some pretty blatant fraud. But it is early. The pandemic is still ongoing. As we move further away from the pandemic, the political winds are going to continue to move towards investigating pretty aggressively, we think, some of these programs to make sure that the programs were used properly and that the government's money has not been abused. And you need to know that even if you did nothing wrong, you're clean as a whistle, you may find yourself on the receiving ends of a government investigation. And D&O insurance can help protect against this risk, which is likely to grow over time. So under these policies, generally what's covered? The answer in its shortest version is that they cover claims against the company's directors and officers for wrongful acts, which is defined in the policy. Typically, it includes error, misstatement, misleading statement, act, omission, neglect, breach of duty. In other words, it is a broad initial definition to find out what might be covered under the policy as you work through the terms and conditions. The types of policies that are issued to private companies, in other words, those that are not publicly traded or that are nonprofit, usually also include entity coverage, which is a type of coverage that applies to claims that are made directly against the company itself. These different coverages are typically arranged. This is a little bit of insurance lingo, side A, side B, and side C coverage. But they're arranged in the policy under separate sections. Side A refers to the claims against the directors and officers, okay? And side A coverage will directly cover that exposure, usually without a deductible. Then there's the indirect version of that same exposure. Again, claims against directors and officers where the company has chosen to reimburse the directors and officers or indemnify the directors and officers against that claim. And here, the company's decision to reimburse is covered under the policy under side B, but generally with a deductible. Then side C is the entity coverage that I referred to a moment ago, and that covers claims that are actually made directly against the company rather than against an individual director and officer. So those are the three basic categories. With that, now Brian is going to talk to us at some length about going to the market and applying for coverage. Brian?
Hey Alex, how you guys doing? Really enjoy everyone being here today, and it's our pleasure to to educate everyone. As Alex mentioned, we did one of these before, and even though it was a bit coincidental, we found out the format. We got excellent feedback back from everybody, realizing that from Alex's side, he's really getting into the depth of what to watch out for. But we also realize that it's important to know where to start and hold your hand at the beginning. So due to that great feedback we got, this is why we decided to do a series just to really help our clients and those that are really interested in these different type of insurance nuances. That being said, let's get into the application considerations. Obviously, it's the first one's pretty obvious. It is critical to review the application questions in detail. Make sure to watch out for certain words: prior to, preceding, relating to. So many times clients will just miss a single word and they're answering you completely incorrectly. But at the same time, they might be providing something that the underwriter starts to look further into. So it's very important to look at the words in detail and really keep in mind for certain little words that could completely change your answer. The second point, elaborate on responses where a simple yes, no may be misleading or inaccurate. What example? Are you looking to raise more capital? Many companies say, no, we're not looking to raise more capital. But some of them might have an investor that has already agreed to put more investment in if needed. And even though it says yes or no, and you're not actually planning on it, is it worthwhile to actually point out, by the way, we do have a further lifelong if needed because we have an investor that would already pledge further amounts. So it's one of those things that with yes and no, it can be favorable or disfavorable. But you really want to elaborate on those questions and not kind of just put yourself in a box in the application. The third point I always find important, especially over time with my experience, most application questions are pertinent to an underwriter's final terms, and it's important to seek clarity over relevance for your own internal understandings. Some people may not think much into this question, so why is it relevant? The fact is, what you consider a majority shareholder, even if you look at this example, I actually wrote, list all shareholders that own greater than 5% of any class security or the director and officer. And here, maybe people might just overlook this question and not really think much into it. But obviously, this is relevant to the underwriter. And perfect example here, what the economic term is for a majority shareholder is a far cry from insurance terms. Carriers consider 5% or more to be a majority shareholder. It is common for carriers to exclude these suits from investors that control more than 5%. So even though that's questions actually asking that, many people are not aware of what the relevance to that question is. And for you as a director, officer, or general counsel, or CFO, when you're looking at these, you have to realize ask a broker, why is this relevant? Because the one thing I can tell you is many quote proposals will not actually show you this exclusion. It might list condition of majority shareholder, or it might list in a fancy term in the proposal, but not give you the actual details there. And you got to actually inspect the specimen policies. But let me ask this, if you ask this question to the broker, why is this question relevant? I can tell you that even an incompetent broker would need to ask the underwriter to find out that this exclusion may exist in the base form, and at least it makes you aware of it. Next slide. And this is another thing. Unlike other insurance type of applications, directors and officers applications do not inquire about estimating upcoming year revenue expenses. They focus on the past and current financial state. Most of the applications, professional liability, general liability, the carrier wants to kind of get an idea of what you're doing the next year. For D&O, it's just not relevant on the application. But this can create an issue. New businesses typically are not net income positive for a number of years. Existing businesses may have shrewd plans to reduce expenses with little impact on revenues. Obviously, this would all work to your net income positive goal, even though it's not listed there, which I'll get back to in a couple slides later. Side note with nonprofits, I just want to throw this in there. According to a survey by the Insurance Information Institute, of the 31% of companies that had a D&O claim against them within the previous 5 years, the majority, which accounted for about 58%, were nonprofit organizations. The fact is, large numbers of directors and officers for nonprofit organizations lack experience. Oftentimes, they lack sufficient knowledge of the legal duties and responsibilities regarding the nonprofits they serve. Directors and officers of nonprofit organizations who do have knowledge or experience sometimes take advantage of the less formal approach of nonprofits and fail to take the same business approach as decision makers as they would for a for-profit company. It's just a reality. That's exactly why it's critical for nonprofit board directors and officers to all types of sizes, to understand that not all their actions are covered by the Federal Volunteer Protection Act. And, even one claim usually will surpass a lifetime of premium. So it's just important to point out for nonprofits, a lot of people are not thinking about this D&O. And the fact is that's actually the majority of claims come from nonprofits. So it's something to very much keep in mind. My next point there is, when you talk about your revenues, not all nonprofits can receive grants and donations. And it's not necessarily that they're generating revenue off service, but keep in mind that underwriters treat financial stability similar to for-profits. Revenue from services, grants, donations should keep a healthy fund balance vis-a-vis expenses. Next slide. All right, and this is all building up to my point. Supplement favorable information not necessarily requested from the application. New businesses should promote the board's experience and credentials. It shouldn't be based solely on numbers, and don't expect underwriters will pull up the favorable background of an officer. In fact, the underwriters are looking for the negative aspects. So new business, put forward the experience, put forward the credentials, put forward the positives, knowing that your company is being run by experienced people that know what they're doing. Put forward factors that will show the increase in revenues and or decrease in expense debt liabilities. This goes back to my previous slide. Make the underwriter aware that there are factors in motion that the values in the application do not reflect or appreciate. I had one client that they were, about almost 5% non-net net profit, a negative net profit, but they realized that basically within 3 months after their buying date, that they were going to be net income positive. So it's one of those things that, put that information you want to put forward to an underwriter. It might make a difference in them declining it, give you a better rate, et cetera. Also talk about expense and debt liabilities. So that's another one I mentioned. There's certain companies that realize, we're going to lay off 15% of our people because we're bloated. And, the fact is it's actually the revenues may not increase, but their actual net income positive will be strong, much, much, much stronger. So it's these points that you really want to point out to an underwriter. And this goes to my point about the majority shareholder. Explain why a non-board shareholder that has more significant equity position should be a low risk of bringing suit. An underwriter may make an exception here to exclusions for non-board representing shareholders. Now, at the same time, I will tell you, if you can't generally state that a non-board shareholder is a low risk, and the carrier is not willing to augment a permanent majority shareholder exclusion, then my advice is, put them on the board. Because if you put a person on the board, they're not going to sue themselves. It's just the reality of it. And lastly, this is the whole reason. It puts an applicant in an adverse position once the underwriter issues a declination. So just imagine that an underwriter issues a declination, it's through their systems, it's part of the history of the carrier. And then you go back and you found out why. And then all of a sudden the underwriter says, because of this, this, and this. And then all of a sudden you go back saying, well, you know what, that's not completely true because I didn't mention this part. Because at that stage, you got to go back to the underwriters and you got to actually get them to overturn their declination. And that's all in that underwriter's history. And it puts a spotlight on that underwriter. So a lot of times, the fact is some underwriters may not be willing to do it just because if they're right on the edge of a risk, and they feel that it's a possibility they're going to write it, but they already issued declination, chances are those underwriters are not going to overturn it because they don't want a spotlight on them. God forbid that risk went south. And what we have, take caution. All right, talking about the questions here, this kind of gets back to my point on, be aware of certain construction of the question. Take caution reviewing certain application questions here. In the next 12 months, these are examples. These are actually examples from an application. In the next 12 months, or during the past 24 months, is the applicant contemplating an actual proposed merger, acquisition, or divestiture? I can tell you from experience, many times people write down, yes, we did contemplate it. Someone actually, a person wanted to come by and they offered us money for a company and we met with them. So they put that down the application. I can tell you right now that majority, and I say majority, or 50% of the underwriters will not write a business that's currently going through an actual or considering an actual proposed merger, acquisition, and divestiture. Now, at the same time here, what does contemplating mean? Because I can tell you, I think any business owner, any business is not going to turn down an audience that's going to give them an offer. Because if that, I think anyone's going to be open, even if you're not willing to sell your business, you have no plans on. Actually, you can hit an audience and hear them out. Now, is that contemplated? Because I highly doubt that's contemplating. That's just you listening to them. So even though the word contemplating from the English definition could mean that you answer yes to that. It really, the underwriter's really looking that you're engaged in it. You already started the process. You already started doing audits and really engaged in it. You plan on actually selling it or engaging in that offer. So the mere fact of, contemplating, I might want to sell this business. I typically say that that's no to that, because at the end of the day, you're going to put yourself in an adverse position, and the carrier's really looking for the depths of, how far you go until there's no negotiations. Current insurance information, requested insurance terms. The first one, look, the way I look at it, why should another carrier know how much you're paying in premium? I usually tell my insurance to leave that blank. There's only very few times where I disclose the premium, or if I feel like if it's needed. But most times, why should they know how much you're paying? Same thing with requested insurance terms. If you're relying on your broker to really advise you on what they feel benchmark limits are. How do you know what's properly covering you? So you actually putting down, let's say, 1 million, but you find out that the benchmarks in national companies 3 million. You kind of put yourself as a whole there, because the broker's going to get you exactly what you're requesting without actually really showing you what from their experience what you should be purchasing from your average benchmark peers. The last example is the applicant or any person proposed for this insurance aware of any fact, circumstance, situation, event, or act that reasonably could give rise to a claim against them. And I highlighted this, under the liability coverage for which the applicant is applying. So many times I see an application that people have an E&O claim, a property claim, a cyber claim. You're not applying for those coverages. You're applying for directors and officers. So the one end, the fact is, should the underwriter, regard that? Technically they shouldn't, but the fact is you're also disclosing that, hey, we had a professional liability breach that actually occurred. I'm pretty sure it's going to make an underwriter feel a bit uneasy, even though that you didn't really need to represent that because it's not related to the liability coverage for which you're applying for, which is D&O. So once again, it's very important that people review this, or your broker reviews it. Your broker should have questions, because so many times I had my clients read the application, make sure they're answering exactly what the question asks, and we're not, divulging other information that basically it's not being requested. It's as simple as that. COVID questionnaires, talking about the questions. This gets more difficult. And I know it's been, Alex and my lives more difficult here, because the less questions, sometimes the better. Here, carriers started really slapping on additional supplemental questions, especially related to COVID. And once again, this is important because, these are more questions that can lead carriers to deny claim for not properly representing the situation. So it's very careful to answer these. And these are some of the examples. How has the pandemic impacted the company financially? How has it impacted customer contracts or inventory, receivables, supply chain changes? Has the company received a PPP loan? Have lines of credit been affected, or have you drawn down credit lines? Have there been any violations of covenants or events of default triggered? Most people that respond to these questions, there's probably always going to be somewhat negative aspect, but this also goes back to one of my prior slides. Just because you're answering this question doesn't mean that you don't put forward for other information. Yes, this has actually affected our supply chain. But however, we just actually sat here and switched our systems around to accommodate this. Just because it's not asking how you're actually accommodating it doesn't mean that basically you shouldn't put forward more information to make the underwriter feel more comfortable with how you're answering those questions. Current market conditions. Unfortunately, expect the market to harden for directors and officers from increasing exposures. Many carriers have increased premium ratings exposures to compensate for increased claims or activity across the board. However, fortunately, most underwriters have reasonably accommodated current insurance renewals, including staying on risks that normally would fall outside of guidelines. So it's the one side that, yes, you're shopping for new policies. There's less competition as of right now. I assume that's going to be changing in the next 6 months. It's going to open back up. So I don't think this is a permanent thing. It's going to stay around. But like I said, the good part is most carriers, even if there's certain factors that you would fall out of their underwriting guidelines, I probably had a couple clients that was so egregious with underwriting had to jump off. So although the insurance market is, it's unfortunate when you're reshopping your insurance, it is good to note that most carriers are kind of, doing the right thing and still staying on risks, knowing that the next year might be different. So that's the good news there. Do you know renewal considerations when you do comparison shopping? And this is where Alex shines the best. Keep terms wording in mind when evaluating competing quotes and proposals. Starting to see a trend in expand on limitations and or exclusions to push back on. Payroll protection program or other COVID-related funding, which obviously is one of the points of Alex's presentation today. Bankruptcy. This bankruptcy, anytime I see a bankruptcy exclusion, other than basically claims bought by receivers, I always have that removed because even if your company's flush, it can be one moment you're flush and then one moment you're bankrupt. And what happens if you have a bankruptcy exclusion and your investors bring suit to you individually and you find out you do not have coverage? So the bankruptcy, I always try to remove it. And the fact is, even if the underwriter doesn't remove it, pay a little bit more for a different policy that will, because you never know when it might happen. And to be excluded, you're exposing yourself on an individual basis as well as for the company. False advertising. This is an interesting one I've been seeing. Basically, this exclusion would bar coverage for misrepresentation, omissions, mislabeling in connection to advertising or selling your product. What happens if it's an executive decision to market a product a certain way, and then all of a sudden the lawsuit actually happens, even if it might not be directly D&O, but then all of a sudden the investor actually sues on the D&O capacity because that happened. And they related saying, well, this was kind of related to false advertising, even if it's just alleged. And then all of a sudden you find out you don't have coverage. So that's it's an interesting one I've been seeing. And I push back on that many times. Cyber-related breaches. Cyber is a hot topic. There's been more cyber breaches since COVID than probably ever before, everyone working remotely. And, at the end of the day, the question is, if you have a huge cyber, that could be out of your control as a D&O, but what happens if an investor sues you? Realizing that you failed the safeguards to protect our systems, and now we just lost millions of dollars in fines, regulatory, or even stolen monies, and then a D&O claim, and you find out you don't have coverage. So these are the four that you really should push back on if you see them. D&O renewal considerations, additional coverage clauses to explore. Now, all these probably don't really make sense to a lot of people. And if you see it on your proposal, you probably have no idea what it means for most that have not actually gone through the process. But to break it down, you have additional defense limit. Essentially, when you have a limit, if you have a $1 million limit, your defense costs, the cost to defend you, the attorney's fees, as well as the judgment, the actual loss, both normally exhaust your $1 million limit. For example, you have a $1 million limit, it's $150,000 in legal fees, you only have $850,000 to pay out a loss. An additional defense limit actually provides, let's say if your defense, it provides an additional defense to the claims. God forbid if you had $500,000 in attorney's fees, they will provide an additional limit just for the defense. That way you have more money to apply to a loss if there's a judgment or settlement against you. First dollar defense. This is another one to consider. What this means is if it's basically just the claims, meaning that you allege that the directors did something, it hasn't been proven, there hasn't been a judgment, there hasn't been a settlement. Your retention could be $25,000. You will not be paying that out if it's first dollar defense. That means that you're not on the hook. If for defense costs, you're not going to pay $1 unless there's actually adjudicated adversity against you. Now, defense outside the limit is completely different. If you have defense outside the limit, that means it doesn't exhaust your limit whatsoever. Normally, if you have a $1 million policy, I usually recommend defense outside the limit. If you have a higher limits, let's say, multi-million-dollar limits, then it could be a bit different because you do have an extra cushion room for defense costs. But essentially what defense outside the limit means is, those, perfect example, $500,000 in attorney's fees, you still have your $4 million to pay out an actual loss. Retention applying to loss only. This is a little different than the rest of them. What this actually means is that your retention doesn't apply whatsoever, but it'll actually pay for the actual loss itself. So there's different little nuances, but they could dramatically change the difference. And some of these can even be combined. For example, I've seen clients that had first dollar defense and defense outside the limit. So it really, it really matters on how that retention is applied and how the defense claims adjustment expenses are applied. Duty to reimburse. This is an interesting one. It's usually reserved for larger policies to make you aware of that. What that means is you're talking about D&O coverage. You might want to sit here and have your own attorney represent you. You have board members. You want to make sure that your reputation's on the line. You want to designate your own attorney to represent you. You do not want the carrier to represent counsel. Now, we'll tell you from experience, attorneys usually work out great deals with most law firms. Very rarely do I hear an issue with a carrier side of a law firm. So by no means is it bad if you do not have this. It's just one of those things to consider. If you have an attorney that you know that it's going to represent the best of your ability, you might want to sit here and try to sit there. That's an option, because what a duty of reimburse actually means is the carrier doesn't choose your counsel. They just reimburse the counsel that you choose after they get approved. And the last one I feel is very important. You should always ask this one. This is one they should always ask for. Supplemental personal identification coverage. This provides an additional limit for individuals that are still named in suits. So, for example, the company sued, you have a complaint. It sues the company. It sues the individuals in individual capacity. You have a $1 million limit. What happens if that whole entire $1 million limit is defending the claim and you still have your individual officer, your individual named in the suit? What happens at that point? Do you start paying out or out of your own pocket? What this actually does is that this will provide an additional limit. A lot of times it's an extra $1 million to cover individuals in suits. If the limit's exhausted, you're still going to get an extra $1 million to cover you as an individual, which I think is critical, because I don't think I would want to serve on a board if there's any chance I'm paying anything out of my pocket. Further D&O renewal considerations. Companies may expand into non-US territories and subject to foreign courts. It's essential in confirming claims will be covered in overseas jurisdictions. We live in a global era. This is starting to happen more often. Even a small company. I have a company that had 15 employees, and 3 of them had an office in Spain. So with the global era, your exposure overseas does become more greater. It becomes a lot more easily to access overseas. And it's common for the policy, and this is one example, it's common for policy to cover wrongful acts that occur worldwide, but will the carrier defend a claim that's filed and maintained in a foreign court? This means that, let's say that you had a claim that came out of Europe, but for something you were doing out there, but you were sued in the United States, all right, you're fine. There's no problem there. The other issue is if the policy states that, we're going to cover wrongful acts worldwide, but the claim has to be brought into the United States. It has to be adjudicated by United States courts. Once again, if the policy term delineates that, then you're kind of stuck in a box. Now, if it doesn't, it might say that, we cover any claim worldwide, even adjudicated in a foreign jurisdiction, wherever the insured is, or wherever, this actually says insured, it's the insurance carrier, I apologize. It's the insurance carrier's license. That's actually a typo on my part. Because what happens if that carrier is not licensed in that country? Right? And it's something to find out, because if you find out that insurance carrier is not licensed in the country, even though you feel you have worldwide coverage, they'll defend you anywhere. If they're not licensed in that country, they can't defend you. They can't identify you under the policy term. This is something to keep in mind too, though. Carriers can offer multi-line management liability form that can package together several coverage lines. For example, employment practice liability, crime, fiduciary liability, cyber and privacy, etc. The overall pricing can be discounted, and I've got some excellent rates for clients that are unbeatable because of that. And it makes it, policy administration more convenient. However, keep in mind, some carriers' forms for particular coverage lines may not be as strong as others. There's some carriers that were the pioneers of cyber, and their form has grown dramatically compared to other carriers. So just because a carrier is good in one area doesn't mean a multi-line form, all those different coverages, you can't get maybe more cost-effective coverage and more breadth from another carrier and carve out those certain sections. And also keep in mind, this is one thing to watch out for. I've seen this. They also may combine lines with shared limits. For example, let's say I have employment practice liability. I have directors and officers. It shares a $1 million limit. That means if you have a claim for, let's say, discrimination that falls under one line item, you find out that claim's going to erode your overall limit. So most times I'm not comfortable with shared limits. I usually like them separate because at least it gives you your full entire limit throughout the policy year to cover multiple lines, which you can easily, if you're a growing company, Alex knows best. These are closed-made policies. It's the chances are you're not doing a couple bad things in one year. What happens if you're slammed with a couple of lawsuits because of the past several years? So it's a couple bad things. It just happens that those claims occur and they were submitted that year. So it's something very much keep in mind. And with that being said, I'm gonna give it back to Alex right now.
All right, thanks a lot, Brian. A very good summary of some of the things you're going to be thinking about going into the market. Much appreciated. I'm going to move into some of the specifics that you can look for as a policyholder when you're working with somebody like Brian to get the best possible coverage. We've got this organized into different tips as we work through it to sort of give you a finite list, but I'm going to tell you right now, I think that we have 6 tips listed here. We could have easily done probably 26 or even 36 tips. So we're going to highlight some important issues for you to think about, but this is by no means everything. And that really kind of plays into this first tip, which that this is not your auto or general liability policies. D&O policies in general are more complex than those types of policies. And the types of claim scenarios, in other words, the types of lawsuits that you might get tangled up into and look to your D&O insurer to help with, those situations are more complex and more varied than what you're used to under maybe those other simpler forms of coverage. As well, the wording of D&O insurance policies varies more widely than, again, general liability, auto, workers' compensation. Those policies are very standardized. D&O policies can vary quite a bit, and they do vary quite a bit. There are a lot of policy forms that have a lot of things in common with one another, but there's a lot of variances, and those variances are often very important and can be dispositive when you're trying to get coverage. You really should use your broker as a resource, and you really should ask questions. As you can hear from Brian's presentation, doing the application for insurance is not a simple matter, and it is not simple or it's not obvious to understand why some of the questions are being asked or how you could improve your position vis-a-vis the underwriter by giving more information that the insurance company perhaps isn't directly asking for. So work closely with your broker, stay in close contact and ask questions. And then ideally, you should get advice from coverage counsel. We see that, directors and officers insurance policies are fairly expensive to purchase, and the risks that they're covering are even more expensive. Most clients, if they were going to enter into a commercial relationship, a supply relationship, a purchase relationship, a lease, a merger acquisition transaction, they would consult with their counsel over the terms. We find that really, it seems that many clients, many policyholders are underutilizing their lawyers when they go out and buy this, again, fairly complex and very important coverage. They're not going out and using their professionals the way that they ideally should to maximize their position. All right, tip number 2. These policies are claims-made policies. That's how they're organized, right? We highlighted in the beginning that the starting point is wrongful act, but just as much the starting point is a claim. Claim is something that's going to be defined in the policy, and the definitions of claim are not all the same. And what you want to look for is the broader versions of claim, because that's going to give you the maximum possible coverage. It could include, for example, demands for non-monetary relief, injunctive relief, the cost of defending against criminal proceedings, administrative investigations. When you look at the particular definitions of claim between one form and another form, there could be a really significant difference in how broad that coverage is, and it might justify, for example, spending a little bit more with a carrier who gives you a much better definition of claim. right? So when you secure this broad definition, you're increasing the scope and the value of the insurance policy you're purchasing. And again, that's not going to be at insignificant cost. And especially if a risk matures into a claim, these are potentially large claims. So, you're going to want to sweep as much as possible within the scope of that coverage. And the time to try to find that is on the front end when you're working with someone like Brian and going into the market. Once something happens, a claim happens, it's going to be too late to renegotiate that term. Tip number 3 is closely related, right? Just as the insurance policy defines claim, it also defines loss. For those folks in the audience who haven't had the pleasure of reading insurance policies before, it might seem a little odd that these terms are defined, right? These are very simple terms: claim, loss, very simple, very straightforward terms. But in the world of insurance, these are defined, and they're defined sometimes in definitions that are quite a bit longer and more involved than you might expect. When it comes to loss, it almost always includes damages, compensation, judgments, right? The types of money awards that would happen if you lose a lawsuit. But there are, again, much broader forms that are fairly common, but not universal. And those can include things like civil penalties, right? We know that there are statutes out there that not only provide civil causes of action, but also provide specific monetary penalties if there's an adverse verdict on that. It could also include fines, for example. Again, these are things that you would not expect to be covered under auto and general liability type coverage, but you could potentially get coverage for in your directors and officers liability insurance program. I think that does, again, highlight the potential value of this coverage, but you have to make sure that you do your due diligence on the front end to get the best possible language and to buy a high quality form that includes these things. Another aspect of loss is that when you get civil fines and penalties, you're typically talking, when you get this coverage, you're typically talking about non-intentional, non-willful conduct, right? So if you see a form that includes civil penalties and fines, it may likely also have a provision that says that the conduct that leads to those fines cannot be intentional or willful. That's not surprising, although we've already mentioned that there is some coverage for intentional allegations of intentional act and also other types of intentional acts, which will highlight as we move through some of the additional tips we're gonna hit after this one. Basically, the lesson here is the same, that the broader the definition is that you secure for loss, it's going to lead to coverage for a wider variety of claims, lawsuits, investigations, administrative proceedings, etc. Very beneficial to get this additional language. Again, when it comes to defense costs, it's important to keep in mind that very often policyholders find themselves on the receiving end of lawsuits, investigations, et cetera, when they have done nothing wrong, and they may ultimately be vindicated, right? You might ultimately win your case, but the cost of the defense can be very substantial. And, that's particularly true where not only are you fighting over large dollar amounts, but, you may need lawyers to defend these cases that are more sophisticated than the lawyers that your auto liability insurance company will assign if one of your people gets into a car accident, right? Just for example, an auto liability defense counsel might be billing at $200 per hour, a very low rate. Highly unlikely you're ever going to see a directors and officers claim with anything like that type of rate, right? You're dealing with much more sophisticated counsel who charge a lot more. So the defense costs are going to add up. So you may not be thinking that you're the type of company that's going to be entangled in an allegation of intentional wrongdoing, and you're probably right. You probably have a good sense of that you're not doing something wrong, but you can get tangled up in that, and the cost of proving that you're in the right can be quite substantial and really highlights the benefit of these policies. The fourth tip is to narrow what's called the conduct exclusions. As we've talked about, most types of insurance, we generally think about insurance to protect us against the consequences of our mistakes. You buy auto insurance because sometimes you might not be careful enough. You might just, not pay attention for a moment and cause an accident, not intentionally, but you make mistakes. And you buy insurance to protect you against those mistakes. You don't usually buy insurance to protect you against intentional wrongs. And for the most part, you really can't do that. There's case law in most states across the country that says you cannot insure against the consequences of intentional harms. But directors and officers liability insurance provides a pretty wide area for possible coverage against these types of things. It includes exclusions for intentional conduct, but the way that those exclusions are worded can put you in a fairly good position if you find yourself on the receiving end of a lawsuit that alleges fraud, criminality, dishonesty, etc. So the way the exclusion is written usually has a proviso, and it's called final adjudication language. That's shorthand for this particular clause, of which we have an example here on the screen. So these conduct exclusions could say, for example, we're not going to pay for loss, quote, arising out of any deliberate criminal or deliberate fraudulent act by the insured. Again, makes sense, right? You're not going to get insurance for that sort of thing. But it goes on to say, if a judgment or final adjudication or any binding arbitration proceeding adverse to the insured establishes that such deliberate criminal or deliberate fraudulent act was committed. Well, I think you can see, number one, if you're successful in defending against this claim, you're going to be covered, right? If you get a final adjudication in your favor, then you're covered for the defense costs. But it's actually broader than that for a couple of reasons, right? Number one, a settlement is not going to be a final adjudication. So most civil cases are ultimately settled and don't go to verdict. So there's a wide area in here for potential coverage with claims that are settled. And there may also be the ability to sever this exclusion for different insureds, because not every insured may have the same intent. One of the directors or one of the officers might have been involved in something intentional that the other directors and other officers did not know was going on, and they found themselves. So if the exclusion is phrased with the insured rather than an insured, it might be severable and therefore provide a higher degree of protection to the apparently innocent insured. You can also try to eliminate the insurer's ability to recoup the defense costs that are spent before there's a final adjudication. So again, this is an important set of terms in the policy that can really broaden and enhance the value of the policy if you're careful to look at these terms. Tip number 5, severability. This is a really important one, and it has particularly come up, or it has come up in ways that has been reported in the news with publicly traded companies, where publicly traded companies have been sued in securities class actions for false statements in their accounting statements, fraudulent accounting statements. But it really does apply across the board. I mean, those are the cases that are reported in the news. But you need to understand that if a big claim comes in, the insurance company or the insurance company's lawyers are going to look back at the policy, look at the application, and to see what was said to them at the time they issued the policy. And if they feel that they were not told the truth, they might seek to rescind the policy and basically make it null. When you get the severability language, though, there can be a significant amount of benefit to anyone who was not actually involved in the misrepresentation. For example, perhaps the company's CFO signed the application and provided the financial statements to the insurance company and knew at that time that there were false statements in the finances. Perhaps the board members, though, were totally unaware. They assumed the information they were getting from their CFO was accurate. With full severability, the rescission will only affect the CFO, and it will not be imputed, right? That's the legal term, to the other insureds for a rescission claim. So this idea of imputation is, even though you didn't know, we will treat you as knowing because your agent, the CFO, was aware. So if you get this full severability, it could be very powerful in instances of some very bad conduct that you personally were not involved with. Tip number 6, narrow the bodily injury exclusion. This particular exclusion, it's, when you look at exclusions, they are very often placed into insurance policies because they create the dividing line between different types of coverage, right? Your general liability policy has an exclusion for automobile claims. Your auto liability policy is not going to cover general liability claims. Well, your directors and officers liability is going to exclude bodily injury claims because bodily injury claims are going to be covered under one of those types of policies. A general liability for the premises and products liability, and et cetera. So this is a dividing line type exclusion, but if it's written too broadly, it can create a gap rather than just a division between the different types of insurance. So the broad form of the exclusion says the insurance company is not going to cover any claims alleging, based upon, attributable to, arising out of, in consequence of, or in any way related to bodily injury. That is too broad, right? That form could capture financial losses that have some connection to a bodily injury claim. In other words, that could capture claims that are not actually filed by an injured person, right? You want to get the narrower form, the narrower form of the exclusion, which basically says there's no coverage for claims for bodily injury, meaning they're not going to cover the claims that are filed by people who were actually physically injured. And an example here to illustrate the difference is you could see a claim alleging that that management did not respond properly to COVID risks, and as a result, people got injured. And as a result of that, the company had some financial injuries. That type of claim ought to be covered under the narrower form of the exclusion, but potentially might not be covered if you have this very broad wording of the exclusion. So that one is worth your time to try to get it out of the policy. And, normally that's not too difficult of a task. But if you're not paying attention, you could be saddled with this gap between different types of coverage.
And Alex, just to jump in here,
Yeah,
one glaring fact that we should mention to everyone and why you should make this due diligence important is the fact is your failure to obtain the correct or adequate insurance could lead to a D&O lawsuit in itself. So that's something we didn't mention, but it is true. If the board doesn't practice a good due diligence over the insurance it's procuring, that could also lead to your own D&O claim.
Yeah, that's true. And I think that really speaks to this final slide, right? Which is if you're a director or an officer, if you're part of the management of an enterprise and, you are entrusted to some degree with managing these risks that could be offloaded to insurance companies rather than retained by the company. I think, this slide here really speaks to what should you be doing? How should you be making sure that you've done your job properly? I think the main point is become informed. Hopefully this webinar will help with that, but you also need to rely on your professionals, right? Remember what they do, understand what they do, and then use them in the right way. So hopefully we've emphasized today by covering different subjects that your experience and my experience, your skills and my skills are not identical. We overlap, right? But for somebody like you, Brian, your experience is mostly focused on the marketplace. What policies are available? What's the pricing? How do I interact with these insurers? What can I get? What will insurers give if I ask? What will they give if I pay a little bit more? What will they not give no matter what I say, even if I jump up and down and offer to pay them tons of money? Right? So I don't have that expertise. You do. Whereas on our side, as the lawyers, we are focused more on the legal meaning of the terms, right? We look at the paper that is printed, what do those terms say, and examine them very closely and try to figure out, are there holes? Are there things that we ought to close up? We, of course, have some overlap in doing that, but I think, people need to understand the difference between the two roles. And this is, really in my mind is a pitch for somebody like you, Brian, which is particularly smaller, often private companies, but particularly smaller companies, growing companies, might be rolling along with the friendly neighborhood insurance broker who bought them the first couple policies when they opened their shop, right? Maybe the first simple set of policies. And now they've gotten more sophisticated and they have significant D&O exposures. People need to keep in mind, business owners, business leaders need to keep in mind that friendly neighborhood broker might not know what you know, Brian, and they really need to make sure they've gotten some sophisticated help with these policies. And I think if people take nothing away from today other than that, it's at the very, very minimum.
Yeah. And another point to bring out here, Alex, is the difference is, I can tell you what current forms are and what's being offered, but I'm not in the courtroom every single day. I don't know if there's legal precedence that defines a certain term, and there's actually court precedence that actually shows that a certain term, even though, grammatically, that's how I interpret it. There might be a court decision that's out there that actually says that that's not the way it should be interpreted. And as I said, brokers are not in the courtroom every day, that they're not following them. Then they'll understand some updated precedents that could affect certain languages like Alex has, like Alex understands.
That's a great point. Look, again, I think if people take nothing away from today, hopefully, make sure you're getting good help, and make sure you really rely on, and press your professionals to make sure they're doing the best possible job for you. So with that brings us to the end of our presentation. Happy to say we brought it in on time. We try to give people some really good content in an hour. We seem to have done that. We're just a couple of minutes under an hour right now. I've got our email addresses up on the screen, my email, Brian's email. We please encourage everybody to reach out to us. If you have questions, if you'd like to follow up, if you'd like to learn more about my firm, Brian's firm, please do reach out to us. We've had a good response, a good crowd joined us today, so I expect to hear from a lot of folks, and we're available to you. We're happy to chat and keep the conversation going about this important subject. And the last thing I would say, and I don't know if you have a last point, Brian, but the last thing I was going to say is if anybody has some ideas for things they'd like to hear about in future presentations, please let us know, because we will certainly take that into account as well.
Absolutely.
All right, everybody, that's all for today. We hope to see you again very soon.